The European Union's General Data Protection Regulation comes into force on 25th of May 2018. What does your organisation need to do to comply with the new law? In this session, we discuss the obligations of data controllers. A crucial first step towards GDPR compliance is to identify your organisation's role in relation to personal data. You may be a controller. You could be one of two or more independent controllers in relation to the same personal data or data sets. You could be one of two or more joint controllers, or you could be a processor or sub-processor. While controllers have the main duties and obligations under GDPR, processors also have new and specific obligations, including an obligation to assist and support controllers' compliance procedures. A controller is defined by GDPR Article 4 as a natural or legal person, public authority, agency or other body which, alone or jointly with others, determines the purposes and means of processing of personal data. Importantly, a person can be a controller if they are directly responsible for only one of those elements, for example, determining the purpose of processing, while leaving it to another person, who will be a joint controller, to determine the means of processing. GDPR Article 26 provides that joint data controllers arise where two or more persons jointly determine the purpose and means of processing. Joint controllers must determine and set out their respective responsibilities in an arrangement. That could be a contract, or it could be something less formal, such as a memorandum of understanding or a data sharing protocol. The essence of the arrangement must be made available to data subjects, and data subjects may exercise their rights against each controller. Article 26(3) states that irrespective of the terms of the arrangement between joint controllers, the data subject may exercise his or her rights under this regulation in respect of and against each of the controllers. In practice, this means that when seeking a remedy such as compensation under GDPR Article 82, a data subject can choose which of the data controllers to claim from. The data subject is entitled to recover from the closest, deepest pockets, leaving it to the joint controllers to adjust any loss among themselves. So what are the data controller's obligations? The data controller is primarily responsible and accountable for compliance with the data protection principles. Data must be processed lawfully, fairly, and in a transparent manner, which means that the controller must identify the appropriate basis for processing. The controller must also determine and communicate to data subjects the purpose for which personal data is collected and processed. Controllers have a duty to minimize the amount of personal data that is collected and processed, meaning that data should only be processed to the extent necessary to meet the specified purpose, and should be kept only for so long as necessary for that purpose. Data controllers must ensure that personal data is accurate, and must correct or rectify inaccurate data as and when requested to do so. Those duties converge on the storage limitation. Data controllers are responsible for ensuring that personal data is held in accordance with the data minimization principle, and is erased or destroyed when the lawful basis for processing no longer applies, or if that data is shown to be inaccurate. Completing the controller's primary set of duties is an obligation to ensure that data is kept in a secure manner and that its integrity is protected. Consent provides a good illustration of the nature and extent of the data controller's obligations. If a controller determines that consent is the appropriate basis for processing, then the controller must demonstrate how and when they obtained a data subject's consent. The controller must also demonstrate that they have made it as easy for data subjects to withdraw consent as it was to give consent, and that they have made data subjects aware of their right to withdraw consent at any time. Where consent relates to a young person, under 13 in the UK, the controller must also verify that parental consent or the consent of another responsible adult was obtained for the processing of the young person's personal data. If consent is withdrawn so that processing is no longer lawful, the controller must erase or destroy the relevant personal data from their system and notify any other controllers with whom the data has been shared. It is common practice for data controllers to outsource their processing activities, for example, to cloud service providers. GDPR requires the controller to ensure that they have a written agreement with their processors, and to secure guarantees concerning the processors' technical and organizational measures to ensure data security. The controller remains primarily responsible for data breach, but the processor must be contractually obliged to help. The controller may be obliged to carry out data protection impact assessments. This obligation arises in relation to high-risk processing, where a breach would pose a risk to the rights and freedoms of a data subject. It is an ongoing duty, so needs to be considered whenever a data controller is considering changes to their systems or is implementing new systems. In many cases, controllers must also appoint a Data Protection Officer, or DPO. We cover the DPO's role and responsibilities in a separate session. Should a personal data breach occur, the controller must report it to the regulator. In the UK, that's the Information Commissioner's Office, or ICO, within 72 hours after becoming aware of it. If the breach creates a high risk to data subjects' rights and freedoms, it may also be necessary to report it to the individuals affected. Even where individual breach notification is not required, the controller must maintain a breach register. This should enable the controller to identify any patterns or common factors in breaches that occur. It also provides evidence allowing the controller to respond to any regulatory intervention or to claims for compensation made by data subjects. A new element of GDPR is the express inclusion of the accountability principle. A controller must comply and must be able to demonstrate compliance with GDPR requirements. The accountability principle is a pervasive feature of GDPR. It can be seen in Article 24, which requires the formulation and adoption of data protection policies. It can be seen in Article 25, which requires the controller to implement data protection by design and by default. Data protection must not be regarded as an afterthought or a bolt-on, but must be designed into systems and procedures from the outset. The accountability principle is perhaps at its most visible in the Article 30 requirements for written records. Those records must document key decisions, procedures and safeguards, and must be made available to the regulator on request. A headline feature of GDPR is the significantly increased level of potential regulatory sanctions. Tier 1 fines can reach up to 2% of an organisation's global annual turnover, or 10 million euros, whichever is the higher. For more serious breaches, Tier 2 fines can reach up to 4% of global annual turnover, or 20 million euros, whichever is the higher. It's important to remember, though, that fines are a remedy of last resort. Regulators have a full toolkit of other enforcement powers, including, for example, stop-now orders, orders which may ban the commencement or continuation of particular types of processing. Even where fines are imposed, any steps taken towards compliance may be taken into account and may reduce or mitigate the penalty that is ultimately imposed. As well as administrative fines, GDPR also provides for compensation. Under Article 82, any person who has suffered material or non-material damage as a result of an infringement of this regulation shall have the right to receive compensation from the controller or processor for the damage suffered. It's important to note here that non-material damage can include distress. This is an area in which the distinction between controller, independent controllers and joint controllers becomes particularly significant. Controllers or independent controllers are responsible for their own default and for a default on the part of their own processors or sub-processors. Where there are joint controllers, data subjects may claim full compensation from any of them. It is then left to joint controllers to adjust loss and recover an appropriate proportion from the others. Given this risk, it is strongly advisable to identify any situations in which your organisation may be found to be a joint controller. Should you have any queries, or if you would like to seek advice on any of the issues discussed in this session, please contact our data law team. Contact details are on your screen at the moment. Thank you for listening to this GDPR webcast. Please join us for our other sessions on data processors, data protection officers, data privacy impact assessments, GDPR contractual issues, and responding to personal data breach.